It's my pleasure to welcome Luka. Thank him for travelling over here, and he's in very fine form. I've had an enjoyable chat over coffee with him about the comparative differences of the university in Zagreb and in Singapore, and there's a lot to be learned. But more than that, he is an academic who cherishes allowing other people to learn. And, some academics, they're just so wrapped up with their own learning that they don't think anybody else has got anything to contribute. And Luka is the complete opposite of that. His pioneering work, which I'm sure is going to be regarded more and more significantly over the years, is Jurisprudence in the Mirror, which was a collection that he masterminded, inviting civilian lawyers to contribute chapters and then common lawyers to contribute commentaries on those chapters. And it's a work both James and I contributed to, as well as Nicole, one of our former colleagues here. And it was a real eye-opener just to have the privilege of contributing to it, and then reading some of the other stuff in the volume has been amazing. So Luka is a man of generous spirit and highly methodologically motivated, and he's come here to share his methodological observations on legal science as understood by civilians, and we're looking forward to learning a lot from him. Luka, thank you.
Thank you, Andrew. I first want to thank Andrew for inviting me to this spectacular country and to this, I think, even more spectacular legal theory group, which I think is one of the most important legal theory groups in the world at the moment, even though it's a small one, but very, very good group scholars. I'll talk today about methodology of continental European legal science. This is something that I've been working on for years, but I'll tell a bit more about that in the discussion part of our today's symposium. So the main idea that I would like to share with you today, and that I would like for you to take away from this symposium, is that legal theory, at least as I conceive it, as is conceived in Spain and Italy, for example, is to a great extent, in fact, the methodology of legal science. And I'll try to show this today in the presentation. Legal science, as any science, deals with, quoting, studying a certain aspect of the world that falls within its scope of interest, end of quotation. This aspect of the world is the content of the positive law regulation of human conduct. Or more precisely, legal science primarily deals with studying the legal qualifications or legal consequences determined by valid legal norms for classes of human conduct, or more broadly, factual states of affairs within a particular legal system. Thus, the primary subject matter of legal science is the content of positive law. However, the scientific nature of legal science with a thus determined subject matter, that is, legal science in its core sense, legal doctrine or legal dogmatics, is frequently disputed. The non-scientific outlook on legal science is fostered, among other things, by the absence of an explicit methodological framework for conducting legal scientific doctrinal research. For this reason, one increasingly comes across works striving to present a methodological framework of legal scientific research comparable to those of other sciences. Nevertheless, none of the methodological frameworks expounded thus far seem sufficiently elaborate and rigorous, particularly with regard to the fundamental objectives of legal science, the formulation of research questions and hypotheses, and the methods of testing those hypotheses. This is because the said literature fails to consider the insights of contemporary Continental European and Latin American analytical legal theory, which, by relying mostly on a logical linguistic analysis of legal scientific discourse, contains in fact the most rigorous and clear exposition of all the essential elements of the methodological framework of legal science, including clearly and rigorously determined basic legal scientific concepts. However, one disadvantage of the analytical legal theory is that it often falls short of explicitly presenting these elements as the very elements of the standard methodological framework of scientific research. Consequently, the basic aim of the paper is to expound a more elaborate and rigorous methodological framework of legal science that is grounded in the insights of contemporary analytical legal theory. The paper will focus on 5 key objectives of legal scientific research: describing law, explaining law, evaluating law, recommending better law and better interpretation and application of law, and finally, systematizing law. Based on an analysis of contemporary analytical legal theory literature, the aforementioned research objectives will be laid out, and for each objective, possible research questions and hypotheses will be stated, and the appropriate methods for testing the hypotheses described. The secondary aim of the paper is to show that, given the method it uses, logico-linguistic analysis of legal scientific discourse, analytical legal theory to a large extent amounts to the methodology of legal science. Legal theory is the methodology of legal science in 2 ways. First, insofar as it builds the basic conceptual apparatus of legal science by constructing concepts suitable for a legal scientific description of law, such as the concepts of legal system, legal source, legal norm, legal principle, legal rule, normative hierarchy, legal validity, legal right, legal obligation, legal gap, and antinomy. Secondly, insofar as it builds the theory of legal interpretation and reasoning by constructing concepts suitable for a further and more in-depth analysis of legal scientific discourse, such as the concepts of cognitive, adjudicative, and creative interpretation, interpretation in abstracto and in concreto, juristic construction, balancing, construction of unexpressed or implicit norms, and concretization of principles. The paper will not consider some important legal methodological questions, such as the methods of collecting research data, the method of conducting a systematic review of legal scientific and other literature, the theoretical and normative frameworks of legal scientific research, and the methods and functions of constructing legal dogmatic theses. In addition to the introduction and conclusion, the paper is divided into 5 sections, each of which relates to one of the analyzed objectives of legal scientific research. Each section first expounds on what the objective of legal scientific research in question consists of, then formulates corresponding research questions and hypotheses, and finally states and briefly describes the methods suitable for testing the formulated hypothesis. For the purpose of analytical precision, the paper presents both research questions and hypotheses, although in the case of most legal scientific research, due to its frequently explorative and qualitative nature, it is fitting to put forward only research questions and omit hypotheses. In order to keep to the time limit for my presentation, I will only read out the research questions. And I think you have research hypotheses in your handouts. However, when I discuss the methods, I will refer to the testing of the corresponding hypotheses, that is, the tentative answers to the research questions. The basic objective of legal science is to describe the existing legal regime of a class of human conduct, or more broadly, a class of factual states of affairs in a certain legal order. For example, to describe the legal regime of copyright protection, civil liability, land consolidation, license agreement, artificial intelligence, cybersecurity, in the, for example, creation legal order. Describing law is the basic objective of legal science in the sense that it is the first step of any legal scientific research. It can also be the sole objective of legal scientific research, but is often accompanied by additional research objectives such as explaining, comparing, evaluating, recommending, and systematizing, i.e. doctrinally reconstructing law. Describing law consists in determining a set of legal norms that regulate a certain class of actual states of affairs within a certain legal system. Describing law always includes the first level of systematization of legal material, given that a legal scientist describes law using certain conceptual categories and typologies. These can be conceptual categories and typologies used by the legislator in formulating a normative text, the legal scientist himself or herself for the purposes of his or her research, or those developed by legal science to date. Of course, the most basic conceptual apparatus used by the legal scientist for describing law is always the one built by us, by analytical legal theory. That is, concepts of legal norm, legal principle, legal system, source of law, retroactivity of norms, legal validity, etc. It is possible to distinguish between at least three ways of describing law. First, identifying the meaning content of normative texts or sources of law. Second, identifying the prevailing doctrinal interpretations of normative texts and juristic constructions. And three, identifying the norms actually applied by judges and other law-applying organs. The first two ways of describing law belong to the so-called normativist understanding of legal science, describing law in books, while the third one comes under the so-called realist understanding of legal science, or describing law in practice. As will be shown in what follows, all three ways of describing law belong to the cognitivist discourse of legal science, since legal science describes law by exploring certain facts, that is, legal existence of norms, or their membership in a certain legal order, and infers about them on the basis of some other facts. For example, that a competent norm-creating organ made a certain normative formulation, legal provision, that it was published in the official gazette, that the doctrine prevailingly ascribes to it a certain meaning, or that in view of linguistic rules and generally accepted rules of interpretation, it can be ascribed certain meanings, or that this normative formulation is prevailingly interpreted and applied by judges in a certain way. When law is described by identifying the meaning content of normative texts, the following descriptive research questions may be formulated in the research. Q1. Which norms can be derived from provision P on the basis of shared linguistic rules, prevailing techniques of interpretation, doctrines, and previous judicial decisions in a legal community LC? Or Q2, which subclasses of actual states of affairs can be subsumed under class of actual states of affairs F, regulated by norm N, on the basis of shared linguistic rules, prevailing techniques of interpretation, doctrines, and previous judicial decisions in the legal community LC? To test the corresponding hypothesis, one can use the method of cognitive interpretation of normative texts. This method consists of the following steps. First, identification of relevant legal provisions, those that prima facie seem to relate to the normative problem that is the subject of the research. That is, identification of relevant sources of law. Second, identification of linguistic rules, interpretive methods which lawyers regularly use in the relevant legal community, doctrines, and previous judicial decisions. 3, possible precisifying reconstruction of identified interpretive methods. And 4, application of each of these methods to the relevant legal provision, which requires identifying the set of interpretive resources linked to each of the methods. For example, dictionary definitions, preparatory works, doctrinal theories on legal concepts and intuition, institutions, moral and political doctrines, etc. Finally, one needs to formulate the cognitive interpretive sentence expressing the result of previous activities, and this is the hypothesis. According to Pierluigi Chiassoni, the above steps represent the so-called hermeneutical experiment. Quoting Chiassoni, on the basis of data gathered from legal experience, the experiment purports to investigate the hermeneutical capacity of an individual legal provision. End of quotation. Describing law by identifying the meaning content of normative text is suitable, for example, for presenting the content of law arising from a new piece of legislation, for presenting the content of law in legal commentaries, for presenting the content of law when there are doctrinal disputes as to the interpretation of a certain normative text, and or different interpretations of a certain normative text by law-applying organs. When law is described by identifying the prevailing doctrinal interpretations of normative texts and juristic constructions, that is, formulation of unexpressed or implicit norms, the following descriptive research questions may be formulated. Q3. Which norm did legal scientists S prevailingly derive from provision P by means of interpretation during time period T? Q4. Which unexpressed or implicit norm did legal scientists S prevailingly construct for factual state of affairs F during time period T? Or question 5. Which subclasses of factual states of affairs did legal scientists S prevailingly subsume under class of factual state of affairs F regulated by norm N during time period T? To test the corresponding hypothesis, one can use the method of analyzing linguistic usage in the interpretive and constructive practices of legal scientists and the method of generalization. First, the scientist has to determine within a population or representative sample of legal scientific texts how in the relevant time period individual legal scientists adjudicatively interpreted provision P. That is, which expressed norm did each of them adjudicatively derive from provision P? Which unexpressed norm did each of them construct for factual state of affairs F? Or which subclasses of factual states of affairs did each of them subsume under class of factual states of affairs F regulated by norm N, and then through generalization infer what the prevailing interpretation, construction, or generic subsumption is in a conformity community of legal scientists during the relevant time period. Describing law by identifying the prevailing doctrinal interpretations of normative texts and juristic constructions is suitable, e.g. for presenting the content of law in legal textbooks, presenting the contents of laws being compared, and for presenting the content of law which research aims to legally or extra-legally explain or evaluate. When law is described by identifying the norms actually applied by judges or other law-applying organs, the following descriptive research questions may be formulated. Q6. Which norm did judges J in time period T actually apply in deciding on a class of factual states of affairs F? Or Q7. Which subclasses of factual states of affairs did judges J in time period T actually subsume under class of factual states of affairs F, regulated by an actually applied norm N? To test the corresponding hypothesis, one can use the method of argumentation analysis of judicial decisions and other decisions of law-applying organs, the method of universalization, the method of abstraction, and the method of generalization. In the case of identifying the norms actually applied by judges in deciding on a certain class of factual states of affairs, the researcher first has to determine, within the population or representative sample of decisions, which norm an individual judge applied in the relevant time period to a factual state of affairs belonging to the relevant class of factual states of affairs. This is done by means of argumentation analysis of the motivations of judicial decisions, which isolates individual premises of judicial reasoning and identifies the content of the first normative premise of the so-called internal justification of a judicial decision, namely the norm expressly stated by the judge as the reason for his or her decision, ratio decidendi. If the norm is not stated expressly, it can be identified through the method of universalization, which, quoting, consists in subsuming by conjecturing an individual decision under a general or universal norm that justifies it. End of quotation. After determining which norm each individual judge applied in the relevant time period to the factual state of affairs belonging to the relevant class of factual states of affairs, the researcher derives by means of generalization a conclusion as to which norm judges actually prevailingly applied in deciding on a certain class of factual states of affairs in the relevant time period. In the case of identifying the generic subsumption prevailingly accepted in judicial practice of certain subclasses of factual states of affairs under a class of factual states of affairs regulated by an actually applied norm, the researcher first has to determine, within the population again or representative sample of decisions, which subclass of factual states of affairs an individual judge subsumed under a class of factual states of affairs regulated by an actually applied norm. Of course, in so doing, he or she will first have to determine, by means of abstraction, to which subclass of factual states of affairs each specific factual state of affairs belongs. After determining the individual subsumptions, the researcher derives by means of generalization a conclusion as to which subclasses of factual states of affairs judges prevailingly subsumed in the time period in question under the class of factual state of affairs regulated by the actually applied norm. Describing law by determining the norms actually applied is suitable, e.g. when one wants to determine the law in action, in particular when research wants to show that there are differences between what is prescribed or norms that doctrine prevailingly derives by means of interpretation from existing normative texts on the one hand, and norms in force, namely norms that judges actually apply in deciding concrete cases. This way of describing law is also suitable, for example, as a prequel to further empirical research into the social effects of applied norms, legal explanation of law, evaluation of the enforcement of an existing legal regime or case law, and recommending better interpretations and applications of law. To a limited extent, it can also be used to make predictions about future judicial decisions. Turning to explaining law. Another important objective of legal science is to legally explain law. That is, inquire into why, from the legal standpoint, e.g. a particular general legal norm belongs to a particular legal system, or is applicable, or has a particular content. In contrast to an extra-legal, e.g. sociological, political, scientific, economic, historical, ethical explanation, a legal explanation of law is an explanation of law on the basis and within the framework of law as a set of general and abstract legal norms. The main focus of the legal explanation of law in legal scientific research is the explanation of the content of legal rules on the basis of legal principles regulating values, desirable states of affairs, or legal political objectives underlying the legal rules that realize or concretize these principles. For instance, explaining the existence of the rule on the hearing of the child in the adoption procedure with the family law principle of the best interests of the child, or explaining the existence of the rule on handling confidential information exchanged at the negotiation stage of the conclusion of a legal transaction with contract law principle of good faith. According to Atienza and Manero, quoting, legal principles have that explanatory function in at least two senses. First of all, because they can synthesize great quantities of information. And secondly, principles enable us to understand the law not just as simple sets of standards, but as ordered sets. That is, sets that somehow make sense. End of quotation. In that sense, as Ratti states, in legal scientific research, legal principles, quoting Ratti, are used to build a sort of explicative theory of existing legislative materials. End of quotation. When law is explained on the basis of legal principles, research can put forward the following explanatory research question. Q8. Why does, in legal axiological, substantive or material terms, rule R or set of rules R1 to Rn exist? To test the corresponding hypothesis, one can use the methods of juristic construction of the justifying unexpressed principle and identification of the justifying expressed principle. Of course, the researcher first has to identify the rules he or she wants to explain in one of the following ways. A. Through adjudicative interpretation of the relevant legal provisions, that is, by choosing one of the possible meanings of each of the analyzed provisions as the most correct meaning, and by argumenting the chosen meanings. B. By identifying the prevailing doctrinal interpretation of the relevant legal provisions. Or C. By identifying the rules actually applied by judges or other law-applying organs. Then, in the case the researcher is seeking to discover an unexpressed principle, that is, a principle not explicitly formulated by the law-creating organ, underlying the set of rules sought to be explained, he or she can use the method of conjecturing about the ratione legis or the method of universalization. The method of conjecturing about ratione legis consists in deriving, i.e. constructing an unexpressed teleological principle, and E ought to be achieved, or value V ought to be pursued, quoting from one or more rules by conjecturing about the purpose of the rules in question. End of quotation. The method of universalization consists in inductively deriving the unexpressed principle, all factual states of affairs that share the element A ought to have the same legal consequence, from a set of rules whose antecedents regulate different complex factual states of affairs containing one shared simple factual state of affairs and whose consequence determine the same legal consequences. If, on the other hand, a researcher is seeking to discover an expressed principle, that is, a principle explicitly formulated by the law-creating organ, underlying the set of rules sought to be explained, he or she needs to determine by the method of conjecturing about the ratione of those rules or the method of universalization, the content of the justifying principle, and then, by analyzing normative texts, sources of law, determine whether the principle in question exists as an expressed principle. Although at first glance it might seem that legal explanation of law, just as description of law, belongs to the cognitive, descriptive part of legal scientific research, it needs to be pointed out that both methods of discovering the principle underlying the rule sought to be explained are for the most part discretionary procedures, and that they depend on the interpreter's value assessments. In any case, the objectives of legal scientific research discussed in what follows do not belong to the cognitive discourse, but rather to the prescriptive discourse of legal science. Evaluating law. As a rule, legal scientists do not confine themselves to merely describing law, but also engage in its legal evaluation. That is, they inquire whether from the legal standpoint, the standpoint of a particular legal system or legal doctrine, the law is somehow good. In contrast to the extra-legal, sociological, political, scientific, economic, ethical evaluation, which is based on extra-legal evaluation criteria, for example, social efficacy, policies, economic efficiency, social welfare, moral principles, legal evaluation of law is based on legal systemic, or doctrinal evaluation criteria. The most common legal evaluation criteria are consistency, completeness, and axiological coherence of the legal regime, correctness of interpretation of normative documents and legal subsumption of subclasses of actual states of affairs under the scope of legal norms, conformity of the legal regime with the prevailing doctrine, conformity of national law with, e.g., international law, European law in the case of European legal systems, the case law of the European Court of Human Rights and the Court of Justice of the EU, and conformity of a national legal regime on a given subject of regulation with the so-called best practices for legally regulating that subject. Roughly speaking, the criterion of consistency of legal regulation requires the absence of antinomies, conflicts between norms. The criterion of completeness, the absence of legal gaps. And the criterion of axiological coherence, the compatibility of norms with norms that are axiologically superior to them. The criterion of correctness of legal interpretation and subsumption requires respect for the rules of interpretation and subsumption in the relevant legal community, and persuasive legal argumentation of interpretation and subsumption that is acceptable to the wider community of legal scientists. The criterion of conformity with doctrine, supranational law, and the so-called best practices requires compatibility of the evaluated norms with the existing doctrinal systematization of the relevant legal regime, the prevailing doctrinal thesis or doctrinal conceptual theories, the relevant supranational legal regime, or the so-called best practices. When evaluating law, the researcher needs to explicitly state the evaluation criteria he or she plans to use, explain them, and state the positive and/or negative indicators for meeting the criteria. Explain why these particular indicators were chosen, what degree of presence of a given indicator demonstrates fulfillment of the corresponding criterion, and what the importance of each criterion is in the event of a conflict between them. In evaluative legal scientific research, it is possible, for example, to formulate the following evaluative research questions. Q9, is the legal regime of a class of actual states of affairs F complete? Q10, is the legal regime of a class of F consistent? Q11, is the legal regime of a class of F axiologically coherent? Q12, is the prevailing doctrinal or judicial interpretation of legal provision P such that it expresses legal norm N correct? Q13 is the prevailing doctrinal or judicial subsumption of the subclass of actual states of affairs F1 under the class of F, regulated by legal norm N. Correct? And Q14 is the legal regime of a class of F in accordance with the existing prevailing doctrine, supranational legal regulation, or the so-called best practices. To test the hypothesis corresponding to question Q9, methods of identifying legal gaps are used. For example, methods of identifying technical, normative, and axiological gaps. The method of identifying technical gaps consists in determining the absence of a norm that is a necessary condition for the legal or social efficacy of an existing norm. The method of identifying normative gaps consists in determining the absence of a norm that links a normative solution to a class of actual states of affairs within the framework of a set of previously identified norms and the sets of classes of actual states of affairs and of normative solutions identified on the basis of that set. The method of identifying axiological gaps consists, depending on the type of axiological gap, in A, identifying the existence of a norm which, according to the interpreter's value judgment, is unsatisfactory, and the absence of a norm which, based on the interpreter's subjective ethical political value preferences, ought to exist. And B, identifying the absence of a norm which, according to the interpreter's value judgment, ought to regulate a factual state of affairs that is, in fact, not regulated. To test the hypothesis corresponding to Q10, methods of identifying antinomies are used. For example, the method of identifying total, total partial, and partial partial antinomies, which consists in determining the degree of overlap between classes of actual states of affairs regulated by two norms that associate incompatible legal consequences with those classes. To test the hypothesis corresponding to Q11, the method of analyzing the conformity of a norm with a legal principle taken to provide an axiological basis to the set of norms to which the given norm belongs is used. This method is used to examine whether and to what extent the given norm is suitable for realizing the principle taken as the evaluation criterion. In order to be able to proceed with evaluating law in view of its completeness, consistency, and axiological coherence, it is first necessary to determine which norms exist within a particular area of legal regulation. This can be done in one of the above-mentioned three ways of describing law. Furthermore, legal scientists often evaluate law after they themselves, through adjudicative interpretation, ascribe meanings to relevant normative texts, which they deem correct. In this case, it is worth noting that legal scientists, through their interpretation, can avoid, but also create antinomies, gaps, and axiological incoherence. Should they create them, they thereby lay the groundwork for recommendatory legal policy action, that is, issuing recommendations de lege or de sententia ferenda. To test the hypothesis corresponding to Q12 and Q13, the method of argumentation analysis is used. The legal scientist presents legal arguments justifying a prevailing interpretation of a certain legal provision or the subsumption of a certain factual state of affairs under the scope of application of a norm, points out the weaknesses of those arguments, and offers additional arguments challenging the correctness of such an interpretation or subsumption. Finally, to test the hypothesis corresponding to Q14, it is first necessary to systematically present the relevant doctrinal systematization of the law, doctrinal thesis or conceptual theory, or describe a supranational legal regime, or using the comparative law method, determine the so-called best practices, namely determine the relevant evaluation criteria, and then assess whether and to what extent the analyzed legal regime meets those criteria. If evaluative legal research shows that the law does not meet certain criteria, legal scientists often proceed by inquiring into how the law could be improved and formulate recommendations for its amendment or its better interpretation and application. Recommendations concerning amendments to the law are recommendations addressed to the legislator, recommendations de lege ferenda, while recommendations on how to better interpret and apply the law are recommendations directed to law-applying organs, most commonly judges. These are called recommendations de sententia ferenda. While for formulating recommendations de sententia ferenda and smaller-scale recommendations de lege ferenda, it is generally sufficient to engage in purely legal scientific doctrinal research larger-scale recommendations de lege ferenda advocating wider reforms will typically require, alongside legal scientific doctrinal research, research belonging to other non-legal disciplines and being grounded in the results of analysis of an extra-legal, e.g. economic, industrial, trade or social policy. Recommendations to judges mostly confine themselves to smaller adjustments to the existing system. That is, those that do not necessarily require the engagement of the legislator and can therefore limit themselves just to, for example, removing antinomies, filling gaps, and reinterpreting specific provisions in accordance with the relevant principles. However, in the case of recommendations de lege ferenda, well, these can also include smaller scale recommendations for which legal scientific research is generally sufficient. They can encompass recommendations for larger legislative changes, which in addition to doctrinal reasons must necessarily take into account the broader social effects of the proposed changes, as well as the axiological aspect of those changes. Recommendation criteria, just like evaluation criteria, can be extra-legal and legal. Legal scientific recommendations are based on the same criteria on which legal evaluation of law is based: consistency, completeness, and axiological coherence of the legal regime, correctness of interpretation and legal subsumption, conformity of the legal regime with the prevailing doctrine, and conformity of national law with supranational law, or the so-called best practices. In the case of recommendatory research, the researcher needs to explicitly state the recommendation criteria he or she plans to use, explain them, justify why he or she chose those particular criteria, operationalize them, that is, specify the indicators on the basis of which it is possible to assess whether and to what extent a particular recommendation could improve the existing law or its interpretation and application, weigh the criteria, and formulate recommendations. In recommendatory research, it is possible, for example, to pose the following recommendatory research questions. Q15A, how ought the judge to interpret legal provision P in order for the legal regime of the factual state of affairs F to be complete? Or Q15B, which norm ought the judge to create in order for the legal regime of F to be complete? Q16A, how ought the judge to interpret legal provision P1 and P2 in order for the legal regime of F to be consistent? Q16B, which of the conflicting norms N1 and N2 ought the judge to eliminate from the legal regime of F in order for the legal regime to be consistent? Q17, how ought the judge to interpret legal provision P in order for the legal regime of F to be axiologically coherent? Q18, how ought the judge to interpret an equivocal legal provision P so that it expresses the correct legal norm, a norm in conformity with the prevailing doctrine, supranational law, or the so-called best practices? Q19, which subclasses of actual states of affairs F, in view of the criterion of correctness of subsumption, ought the judge to subsume under the class of F? Q28, how ought the legislator to amend the formulation of existing norm N to more precisely reflect the meaning of the said norm that does not lead to incompleteness of the legal regime of F? Q20b, which norm ought the legislator to create in order for the legal regime of F to be complete? Q21a, how ought the legislator to amend the formulation of one of the two potentially conflicting existing norms N1 and N2 in order to more precisely reflect the meaning, that meaning which is not incompatible with the meaning of the formulation of the other norm? Q21b, which of the conflicting norms N1 and N2 ought the legislator to repeal in order for the legal regulation of the class of F to be consistent? Q22, how ought the legislator to amend the formulation of existing norm N to reflect that meaning which makes the legal regime of the class of F axiologically coherent? Q23, how ought the legislator to amend the formulation of existing norm N so that it expresses the correct legal norm, a norm in conformity with the prevailing doctrine, supranational law, or the so-called best practices? And finally, Q24, how ought the legislator to amend the formulation of existing norm N to ensure that in light of the criterion of correctness of subsumption, certain subclasses of actual states of affairs are or are not subsumed under the class of F regulated by norm N. To test the hypothesis corresponding to Q15A, Q16A, Q17, Q18, and Q19, one can use the methods of adjudicative interpretation in abstracto and in concreto that avoid the creation of legal gaps and antinomies, ensure conformity with legal principles, the correctness of the meaning attributed to legal provision and of subsumption, as well as compliance with the prevailing doctrine, supranational law, and the so-called best practices. Specifically, in testing the hypothesis corresponding to Q15A, the following methods can be used. The method of extensive interpretation, by which the so-called dubious or hard cases are included within the scope of application of a norm, and B, the method of evolutionary interpretation, by which new cases that were not subsumable under the so-called original meaning of the relevant legal provision are included within the scope of application of a norm. In testing the hypothesis corresponding to Q16A, the following methods can be used. A, the method of systemic interpretation in the strict sense, by which antinomies within the same normative document are avoided. B, the method of conforming interpretation, by which antinomies between different, especially hierarchically ranked normative texts are avoided. C, argumentation a contrario in its interpretative version, which avoids extending the scope of application of one norm to a factual state of affairs that is not covered by the norm's literal meaning and is regulated in an incompatible way by another norm. And D, restrictive interpretation, which excludes, on the basis of the argument of dissociation from the scope of application of one norm, a factual state of affairs that is regulated in an incompatible way by another norm. To test the hypothesis corresponding to Q17, the method of conforming interpretation is used, on the basis of which the researcher, among a number of plausible meanings of the relevant provision, selects the one that is axiologically most compatible with the legal principle considered to axiologically justify the norm expressed by that provision. To test the hypothesis corresponding to Q18 and Q19, one can use the method of argumentation of the trimal interpretive decisions on the basis of rules of interpretation generally accepted in the relevant legal community and standards of the legal regime deriving from the prevailing doctrine, supranational law, or the so-called best practices. To test the hypothesis corresponding to Q15b, methods of legal construction are used, that is, methods of creating implicit norms that fill previously identified or created legal gaps. Implicit norms can be created, constructed, through derivation from expressed norms on the basis of non-deductive patterns of reasoning, e.g. arguments a contrario and a simile, from a combination of expressed norms and dogmatic theses, or directly from dogmatic theses alone. To test the hypothesis corresponding to Q16b, one can use the methods of resolving antinomies based on the following. A, the criterion of hierarchy, according to which a higher norm invalidates a lower one. B, the criterion of chronology, according to which a later norm tacitly repeals an earlier one. C, the criterion of specialty, according to which a more specific norm limits the scope of a norm of a more general one. And D, the technique of balancing. In the case of conflicts between the criteria for resolving antinomies, the methods for resolving these conflicts are used. When it comes to research hypotheses de lege ferenda, those corresponding to Q20A to Q24, the researcher uses the same methods as those used for testing the corresponding research hypothesis de sententia ferenda, but on the basis of the results of using these methods, formulates recommendations to the legislator. Of course, if the researcher formulates recommendations in such a way that he or she also precisely formulates the content of the recommended legislative amendment, he or she will also need to use certain nomotechnical methods. Finally, systematizing law. Systematization is often cited in legal theory and methodological literature as one of the most important objectives of legal scientific research. And I think the most creative one. As has been shown, the first level of systematization is carried out already at the stage of describing law. That is, describing law using certain conceptual categories and typologies, often those developed within specific branches of legal science, like civil law, criminal law. The second level of systematization takes place at the stage of recommendations de sententia ferens, where the researcher recommends ways to prevent or fill gaps, prevent and resolve antinomies, and recommends interpretations of legal provisions in accordance with legal principles that provide an axiological basis for the norms expressed by those provisions. With such recommendations, the researcher seeks to correct certain aspects of the legal regime so that it meets the criteria of systematicity in cases where there is no dispute within the relevant legal community regarding the legal principle or principles on which the given legal regime is based. In this section, I discuss the third level of systematization, which the researcher undertakes when, in light of a specific normative problem, he or she wants to present a comprehensive doctrinal reconstruction of a broader set of norms whose axiomatic foundation, that is, the legal principles that provide its axiological justification, A, is not yet doctrinally established, B, is not prima facie clear, C, is doctrinally controversial, or D, there is doctrinal agreement about it, but the researcher considers it inadequate for correctly resolving a certain normative problem. Such a comprehensive doctrinal reconstruction is derived by presenting a particular legal regime systematically as a consistent, complete, and axiologically coherent set of norms, demonstrating that a given set of norms needs to be ordered, systematized, on the basis of a particular legal principle or a set of interrelated legal principles so as to appropriately resolve a certain normative problem. A highly illustrative example of the systematization of law from Italian doctrine is the ordering of the legal regime of liability for business risk on the basis of the principle of strict liability for damage, so as to extend the right to compensation to those cases of no-fault damage where the legal regime systematized on the basis of the principle of fault liability, the injured party would not be entitled to claim compensation for the damage caused. By systematizing the legal regime, the researcher contributes to the development of existing doctrinal theory of that field of law, primarily the legal regime of a legal institution or branch of law. And in this sense, systematization means theory building and potentially influences legal practice. Specifically, comprehensive systematization of a particular legal regime contributes to A, its better understanding, B, the systematic resolution or elimination of deficiencies in the existing legal regime, which are due either to the absence of or to deficiencies arising from previous doctrinal systematizations, C, the setting of standards for evaluating future legislative amendments and the interpretative and constructive trends of law-applying organs, D, the setting of standards for recommending better law and better interpretation and application of law, E, facilitating interpretation and application of law, and finally F, creating a theoretical framework for future legal scientific research. In systematizing legal scientific research, the following systematizing research question is posed. Q25. According to which legal principle ought a particular legal regime LR to be ordered, systematized, in order to solve normative problem NP? To test the corresponding hypothesis, the following set of interpretative and constructive methods is used. The methods of ascribing to legal provisions the status of provisions that express principles and interpreting those provisions, that is, determining the principles they express, or constructing unexpressed principles, for example, by the above-mentioned methods of conjecturing about ratione legis and universalization, by which the axiomatic basis of a certain previously determined set of norms is determined. Furthermore, the method of creating axiological hierarchies, which includes balancing conflicting principles, if two or more competing principles are derived from a particular set of norms through construction, so as to proceed with the final ordering on the basis of the thus established hierarchical relations of the legal norms of the given set. Finally, the methods of deductive derivation of the logical consequences of legal norms that make up the axiomatic basis of the system, adjudicative interpretation, including that which avoids antinomies and gaps, and conforming interpretation, which uses the level of agreement with the axiomatic basis of the relevant set of norms as the criterion of selection. Then concretization of principles through which more precise, unexpressed or implicit legal rules are derived from principles as its realizations or specifications, serving to fill gaps. Then developing unexpressed or implicit norms to fill gaps. Resolving antinomies, that is, excluding from the given set of norms those that are incompatible with the axiomatic basis. And this is all.